Counsel, it would be my intention in this case, during the plea colloquy, to have that taken under oath with the understanding that that in no way impairs Mr. Grate's right not to make any statement later. I just feel more comfortable in getting the responses as to the plea colloquy, having those made under oath in this case. So, Mr. Grate, before I can accept a plea to the various charges, and by the way, just for the record, is there anything else we need to add to the terms of the plea other than what Mr. Tennell recited for the record and what we discussed up here at the bench?
I don't believe so. The only thing in addition is that we would not be requesting a pre-sentence investigation and a request matter to either proceed to sentencing or be set for sentencing at a later date.
Okay, well, it's not going to be scheduled for sentencing until all the charges in the indictment are resolved, and there'll be one sentencing hearing.
That's what we assume, Judge.
And we'll go from there. So at this time, Mr. Grate, if you'd please stand, I'll have a bailiff administer an oath to you.
Sir, you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, no truth, and nothing but the truth, so help me God?
Yes.
Okay. So, Mr. Grate, as I mentioned, before I can accept a plea to these charges, I need to have a conversation with you, make sure you understand the nature of going forward with a plea to these charges, the consequences of that can result from that, including the potential sanctions that the court can impose at sentencing on these charges, and make sure that you're doing this knowingly, voluntarily, and intelligently, and that you have a full and complete understanding of the various constitutional rights that you're also waiving and giving up relative to these charges and the related specifications to these charges that you've indicated you're willing to plead guilty to today. So, Mr. Grate, are you a United States citizen?
Yes.
And what's the highest level of school or education you've completed?
12th grade.
Are you currently under the influence of any alcoholic beverages or drugs?
No.
Are you taking any medications over the counter or prescription?
No.
Are there any prescription medications that you're supposed to be taking that you aren't receiving?
No.
Have you ever been adjudicated mentally incompetent by any court? Have you ever gone into a court and had them declare you mentally incapable of handling your own affairs and that a guardian was necessary? Okay. And you were able to read and understand this waiver of constitutional rights and plea of guilty document that I have up here at the bench?
Yes.
You've heard the terms of the plea agreement. It's not really a negotiated plea, but basically you're at this point indicating a willingness to withdraw your former plea of not guilty to counts 4, 5, 6, 11, the specification of count 11, 13, 14, 15, the two specifications to 15, count 16, the specification of count 16, count 17, the specification of count 17, count 18, the specification to count 18, and counts 19, 20, 21, 22, and 23, and to enter pleas of guilty to those charges today. Is that correct, Mr. Grate?
Yes, Your
Mr. Grate, did you have a discussion with your attorneys about the timing of deciding to do this today, since a lot of these charges relate to a specific individual that is irrelevant to the other two in this case? Okay, and you're aware that this is something that could have happened before this trial commenced, and evidence that may not be relevant to the remaining charges would have been produced?
I believe we talked about it.
Okay. And what made you decide today, at this point, after all that evidence was in, that now you did want to enter a plea to these specific charges?
Rubbing it in their faces anymore. It already is.
Okay. Was this a decision you came to on your own?
Yes.
And then you advised your attorneys that at this point you wanted to enter pleas to these charges?
Yes.
They didn't solicit that position from you?
No.
Okay. And that's a decision you came to voluntarily?
Yes.
And you understand that we've discussed the fact that because that evidence is already in, and that's not something that would have possibly been presented if we were just left with the remaining counts that'll be there for the jury to decide after we take this plea today, that in essence you're being asked as a part of this plea today to waive any potential error or appeal issue that may result from that evidence having been admitted.
Yes, it's fine.
You understand that that has the potential of influencing a jury.
Yes.
And you're willing to waive any error in that regard?
Yes.
Okay, you understand, Mr. Grate, that a plea of guilty to these various charges and the specifications is not only an admission of guilt, but you're admitting to the truth of these charges and the specifications as they're stated or described in the indictment?
Yes, Your Honor.
And have you discussed with counsel the impact of admitting to the truth of some of these specifications, such as the violent sexual predator specification, and its impact on how that might relate to future proceedings on the remaining charges?
Yes, Your Honor.
You understand that that admission could be used against you later as to any remaining violent predator specifications, violent sexual predator specifications in this trial.
Yes, Your Honor.
And understanding that, you still want to enter a plea of guilty today?
Yes, sir, Your Honor.
Okay. Mr. Grate, have you had the opportunity to review with your attorneys all the essential elements of each of these charges and the corresponding specifications that the state would otherwise have to prove beyond a reasonable doubt if these charges were to go to the jury, as well as all possible defenses that you could still present at this trial as to those charges and the potential sanctions you could face when we get to sentencing?
Yes, Your Honor.
Have they explained everything to you and answered all of your questions to your satisfaction?
Yes, sir.
And to this point, are you satisfied with their advice, counsel, and competence in representing you in this matter?
Yes, Your Honor.
Okay, gentlemen, get out your calculators, because I'm going to need totals here. If you've already done the math, it'll save me having an opportunity or the requirements to do the math. So, Mr. Grate, we're going to review all these counts and the specifications, the potential sanctions. The specifications themselves don't carry a sanction with them, but they do impact the sentencing range and options and the maximum sentences that can be imposed as to the corresponding counts. You understand that? So as I go through these counts and discuss the potential sentences that you could face on each one of these, I'm not going to be talking about the specifications, but the specifications went into factoring or determining what that maximum sentence could be. Do you understand that? Okay, with regard to count 4, the offense of gross abuse of a corpse, which is a felony of the 5th degree, do you understand that the court could potentially impose a prison sanction of not less than 6 months, but not more than 12 months, and impose a fine of up to $2,500? With regard to count 5, the offense of burglary, which is a felony of the 3rd degree, do you understand the court could potentially impose a prison sanction that could run from 9 months up to a maximum of 36 months, and I could impose a fine of up to $10,000? With regard to count 6, the offense of tampering with evidence, also a felony of the 3rd degree, do you understand the court on that charge could potentially impose a prison sentence that could range from 9 months up to a maximum of 36 months and impose a fine of up to $10,000?
Yes.
And you understand that with regard to count 11, count 11 is the offense of rape, a felony of the 1st degree, and associated with that is the sexually violent predator specification. which would require a mandatory prison term consisting of a sentence that's not less than 10 years to life. So basically, it's a mandatory 10 years. At 10 years, you'd have parole eligibility, but otherwise it would be life.
Yes.
And you understand that count 11 also carries with it a $20,000 maximum fine. You understand that count 13, being a felony of the 5th degree gross abuse of a corpse, the court could potentially impose a prison sentence that could range from 6 months up to a maximum of 12 months and impose a fine of up to $2,500.
Yes, Your Honor.
And you understand that with regard to count 14, unauthorized use of a vehicle, a felony of the 5th degree, the court could again impose a prison sentence that could range from 6 months up to a maximum of 12 months and impose a fine of up to $2,500. And you understand that with regard to count 15, the offense of kidnapping with the sexual motivation specification and the sexually violent predator specification impacting the sentencing, you'd be looking at a mandatory indefinite prison term that would be not less than 10 years to life. So you'd have parole eligibility at 10 years, but it could be life.
Yes, Your Honor.
You understand that charge also carries with it a $20,000 potential maximum fine.
Yes.
With regard to count 16, the offense of rape, again with the sexually violent predator specification, that you could be looking at a mandatory indefinite prison term that would be life with parole eligibility at 10 years.
Yes.
And you understand that charge also carries with it a $20,000 maximum fine. And you understand that with regard to count 17, the offense of rape with the sexually violent predator specification, you're again looking at a prison term that would be a mandatory prison term of 10 years to life. And again, a maximum fine of up to $20,000. And then with regard to count 18, the offense of rape with the sexually violent predator specification, that would again result in a mandatory indefinite prison term of basically life with parole eligibility at 10 years. As well as a $20,000 maximum fine. You understand that? And you understand that with regard to count 19, the offense of robbery, a felony of the 3rd degree, the court could potentially impose a prison sentence that could range from 9 months up to a maximum of 36 months and impose a fine of up to $10,000. And with regard to count 20, the offense of burglary, again a felony of the 3rd degree, the court could potentially impose a prison sentence that could range from 9 months up to a maximum of 36 months and impose a fine of up to $10,000. And with regard to count 21, the offense of burglary, a felony of the 3rd degree, the court could again impose a prison sentence that could range from 9 months up to a maximum of 36 months and impose a fine of up to $10,000. Now with regard to count 22, the offense of burglary, also a felony of the 3rd degree, do you understand the court could potentially impose a prison sentence that could range from 9 months up to a maximum of 36 months in prison and impose a fine of up to $10,000. And finally, with regard to count 23, the offense of breaking and entering, a felony of the 5th degree, do you understand the court could potentially impose a prison sanction that could range from 6 months up to a maximum of 12 months, and I could impose a fine of up to $2,500. So you understand as well that when we got to a sentencing hearing, the court could potentially impose all of these sentences consecutively and stack one after the other, and it could impose the maximum fine on each count.
Yes, Your Honor.
So you understand that if these were to be imposed consecutively and you would serve all the mandatory minimums consecutively, Looks like we've got 5 of those 10-year mandatory minimums. You'd be looking at a worst-case scenario in the aggregate, if they're all imposed consecutively, of basically 50 years to life. Is that what your math came up to, Mr. Tennell?
I've got 72 life, Your Honor.
Did I miss a mandatory?
No, there's 1, 2, 50 life is mandatory.
Right.
Overall exposure
His overall exposure is
72.
72 with the other charges added on after the mandatory, yeah. You understand that? Could be 72 years minimum to life. And 50 of that would be mandatory. So there's no good time awarded for that. You understand that?
Yes.
And then did you sum up the maximum fines?
I did. I've got 170,000.
And you understand the worst case scenario, Mr. Grate, at this point in this proceeding, that would be the totals and fines that you could be facing, $170,000.
Yes, Your Honor.
And you understand the court, even on top of that, could impose other financial sanctions such as court costs, day fines, and the cost of any sanctions the court might impose at sentencing.
It's fine, Your Honor.
Do you have any type of professional license, Mr. Grate?
No.
I don't believe this to be so, but I need to ask, are you currently subject to any type of felony post-release control, probation, community control supervision?
No.
You understand that based on the nature of the most serious offenses here, the rapes being F1 felonies, that should you ever obtain release from prison, you would then be subject to a mandatory 5-year post-release control supervision period with regard to those charges.
Yes, I'm aware.
And you understand that if you got released and were subject to post-release control supervision, you also understand that if you violate the terms of that supervision, the parole board could return you to prison for up to 9 months for each violation, with a maximum for multiple or repeated violations being capped at 50% of the court's original prison sentence, which we talked at a minimum would be 50 to 72 years.
Yes, Your Honor.
Half of that's 25 to 36 years. You understand that?
Yes, I understand.
And do you understand that if you should find yourself on post-release control supervision out in the community, if you committed a new felony offense while subject to that post-release control supervision, you understand that at the time of that sentencing, the court could impose as well a prison sanction for violating post-release control supervision by committing a new felony, with that prison sanction for violating post-release control being the greater of 12 months or the time still remaining on post-release control, so never less than 12 months, as much as possibly 5 years, with that prison sanction imposed consecutive to the new sentence, if any, received for the new felony offense that caused that violation of supervision.
Yes, Your Honor.
And you understand, since there's mandatory prison time here, there's still a possibility, notwithstanding that mandatory prison time, that should you complete all of that, the court could decide to impose one of these lesser felonies if it found you eligible, community control sanction that would be served following your release from prison. Well, I'm just saying that's a sentencing option. I'm not committing whether it will or will not ever occur. I'm just telling you that's a possibility. You need to make these decisions fully informed, so it could be, you know, even though you're subject to the mandatory post-release control supervision, this court could also place you on paper should you ever be released from prison on one of the lesser offenses that didn't carry with it a mandatory prison sentence or a presumption of prison. You understand that? And if I were to do that and place you on community control supervision, you understand that if you violated the terms of that supervision, I can impose greater restrictions or sanctions and keep you on community control. I could extend your supervision if it wasn't initially imposed for 5 years, which is the permissible period of supervision, so it could run concurrent with any post-release control supervision. If it wasn't already imposed for that period of time, I could extend it upon a violation, or I could revoke your supervision. And depending on the level of the offense in which the supervision was granted, say it was on one of the F5 offenses, I didn't see an F4 in here. One of the F5 offenses, if it was a technical violation like not reporting to your supervising officer, I could impose a prison term of 90 days without any credit for time previously served. If it wasn't a technical violation, it was a more substantive violation, I could revoke your supervision and impose the corresponding prison sentence, which, let's say it's an F5, would be the 12-month prison sentence associated with that. And if there's more than one F5, so that there's multiple 12-month prison sentences, I could also at that time impose those consecutively if you weren't given a prison sentence at the initial sentencing hearing. Understand that?
Yes.
Okay. And do you understand that if the court were at some point in time on some of these charges, if you had received a prison sentence, in a position to decide to let you out early and suspend the unserved portion of the prison sentence associated with the offense on the condition that you complied with certain community control sanctions? Do you understand that if you violated the terms of that supervision, the court could again impose greater restrictions or sanctions and keep you on supervision, could extend your supervision if it wasn't for a full 5 years, so it would run extra time up to the maximum of 5 years, or could again revoke your supervision in response to a violation and reinstate any suspended portion of a prison term?
Yes.
And you understand, Mr. Grate, that by proceeding with a plea on these charges, you're giving up a number of constitutional rights you otherwise possess as to the disposition of these charges?
Yes, Your Honor.
You understand that you still have a right to have the jury consider these charges and render a verdict on these charges, and to complete this trial as to the extent there's anything left to present with regard to these charges and the associated specifications?
Yes.
You understand you're waiving or giving up that right to a jury trial as to these charges and specifications?
Yes, Your Honor.
Do you also understand that you're presumed innocent of these charges, and until the court either accepts your plea or the jury returns a verdict, you enjoy that presumption of innocence, and you have the right to require that the state follow through and prove your guilt as to each one of these charges and specifications beyond a reasonable doubt to the satisfaction of each one of these 12 jurors we have impaneled. But by pleading guilty today, you're waiving or giving up your right to require that the state prove these charges and the related specifications with proof beyond a reasonable doubt. You understand that?
Yes.
You also understand that you have a right to face, confront, and cross-examine the prosecuting attorney's witnesses, but by pleading guilty today, you're waiving or giving up any further right. Some of that's already happened, as we've discussed, but you're giving up any further right as there may be an opportunity for it in this trial yet as to these charges and the specifications in this waiver of constitutional rights and plea of guilty.
Yes, Your Honor.
And do you understand, Mr. Grate, that you have a right to, as to these charges, to compel the appearance of witnesses to testify on your behalf, because we haven't turned the case over to you to present a defense to these charges yet. You still have an opportunity to do that if you wish, but if you enter pleas of guilty to these charges and specifications contained in the waiver of constitutional rights and plea of guilty, you're giving up that right and opportunity as to these charges to present a defense and to compel witnesses to testify in this trial. You understand you have a right to force witnesses to appear even if they didn't want to help you out. You can compel their appearance through court order subpoena, make them show up.
Yes.
And you understand you're giving up that right by pleading guilty today.
Yes.
You also understand, Mr. Grate, that you have a right to remain silent and to not testify against yourself at trial, and to the extent you're responding to my questions outside the presence of the jury, even though this is under oath, this does not constitute testimony as to any remaining charges, and the court will not admit that as such, nor permit the state to cross-examine you on these statements you're making in response to my questions as to these charges. But as to these charges and the related specifications, you understand that by entering a plea of guilty and thereby admitting to the truth of these charges and the specifications, you're waiving and giving up your right not to testify against yourself at trial, and you're making statements that are incriminating, and to the extent you're admitting to the violent predator specification, the sexually violent predator, or the violent sexual predator specification, get that right, VSP. That admission has the ability to carry over into the violent sexual predator specification associated with any of the other charges that are not resolved with this plea and that still remain for jury consideration or the court's consideration and determination because you've admitted to a status. You understand that? So you understand that you're admitting to a specification that, while it's related to another charge, that admission can come into play as to whether or not a finding is made as to a charge that's not being disposed of today. Okay. And you understand, Mr. Grate, as a result of your plea of guilty to these specific charges and the specifications and your admission to the truth of them as they're stated or described in the indictment, you're waiving or giving up your right to appeal any finding of guilt that the court makes based on your admission to the truth of these charges.
Yes.
Do you understand that you still have a right to appeal any sentence that the court may later impose with regard to these charges, even though you are admitting to them today?
Yes.
And you also understand, Mr. Grate, as a result of your guilty plea today and your admission to the truth of these charges, you're in effect also waiving or giving up your right to appeal any trial errors or mistakes or procedural matters that are errors that you might have otherwise been able to appeal had you let these charges go to a jury for a determination and had the jury returned a verdict of guilty. Those appealable errors that have occurred during the past 7 days, and even in jury selection before that as it relates to these charges, the ability to appeal all those things basically goes out the window, and you lose your right to do that even though the evidence had been presented.
Yes, Your Honor.
Okay. Well, and again, Mr. Grate, you're doing this voluntarily and of your own volition?
Yes.
Okay. And with regard to count 4? Yes.
I think the defendant also has some registration duties pursuant to.
Yeah, that's true. Yeah. Do you understand with regard to these sexually related offenses, even just with the violent sexual predator specification, you'll be classified as a Tier 3 sex offender and have a duty to register for the remainder of your life. Should you ever be released from prison, you'll have a responsibility to report and to reaffirm or re-verify all of that information. Was it twice a year, I think, for every 90 days for a Tier 3 sex offender?
Yes, Your Honor.
You understand that you won't be permitted to live within 1,000 feet of the premises of any school because of that classification?
Yes, Your Honor.
You understand that the sheriff of the counties in which you're required to register may report your residence to other individuals? Anything else I missed, counsel, that you think of?
No, sir.
Okay. Thank you for that reminder. Then with regard to count 4, Mr. Grate, the offense of gross abuse of a corpse in violation of section 2927.01B of the Ohio Revised Code of Felony, the 5th degree, what is your plea?
Guilty, Your Honor.
With regard to count 5 of the indictment, the offense of burglary in violation of section 2911.12A3 of the Revised Code of Felony, the 3rd degree, what is your plea, Mr. Grate?
Guilty.
Mr. Grate, with regard to count 6, the offense of tampering with evidence in violation of section 2921.12A1 of the Revised Code of Felony, the 3rd degree, what is your plea?
Guilty, Your Honor.
With regard to count 11, the offense of rape in violation of section 2907.02A2 of the Revised Code of Felony, the 1st degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to the specification 1 to count 11, that you will be classified or are a sexually violent predator pursuant to section 2941.148 of the revised code, what is your plea?
Guilty, Your Honor.
With regard to count 13 of the indictment, the offense of gross abuse of a corpse in violation of section 2927.01B of the revised code of felony of the 5th degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 14, unauthorized use of a vehicle in violation of section 2913.03B of the revised code of felony of the 5th degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 15, the offense of kidnapping in violation of section 2905.01A4 of the revised code of felony of the 1st degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to specification 1 to count 15, that you committed the offense in count 15 with sexual motivation pursuant to revised code section 2941.147. What is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to specification 2 to count 15, that you're a sexually violent predator pursuant to section 2941.148 of the revised code, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 16, the offense of rape in violation of section 2907.02A2 of the revised code of felony of the 1st degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to specification 1 to count 16, that you're a sexually violent predator pursuant to revised code section 2941.148, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 17, the offense of rape in violation of section 2907.02A2 of the revised code of felony of the 1st degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to specification 1 to count 17, that you're a sexually violent predator pursuant to section 2941.148 of the revised code, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 18, also the offense of rape in violation of section 2907.02A2 of the revised code of felony of the 1st degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to specification 1 to count 18, that you're a sexually violent predator in violation of section 2941.148 of the revised code, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 19, the offense of robbery in violation of section 2911.02A3 of the revised code of felony of the 3rd degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 20, the offense of burglary in violation of section 2911.12A3 of the revised code of felony of the 3rd degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 21, also the offense of burglary in violation of section 2911.12A3 of the revised code of felony of the 3rd degree, what is your plea, Mr. Grate?
Guilty, Your Honor.
With regard to count 22, the offense of burglary in violation of section 2911.12A3 of the revised code, what is your plea, Mr. Grate?
Guilty, Your Honor.
And with regard to count 23, the offense of breaking and entering in violation of section 2911.13A of the revised code of felony of the 5th degree, what is your plea, Mr. Grate? Court finds that Shawn M. Grate has knowingly, voluntarily, and intelligently waived his constitutional rights as to the charges and specifications contained in the waiver of constitutional rights and plea of guilty document before the court, and that he's entered a plea of guilty to those charges and specifications as reflected in the record, and I'm finding that he's made those pleas without threats or promises, that he's has a full and complete understanding of the charges and penalties associated with those charges and specifications, and I'm finding based on his plea of guilty and his admission to the truth of those various charges and the specifications as they're otherwise stated or described in the indictment filed in this case, actually the amended indictment filed in this case. I'm finding that Mr. Grate has committed the offenses and specifications set forth in the waiver of constitutional rights and plea of guilty, that being counts 4, 5, 6, 11, the specification 1 to count 11, counts 13, 14, 15, specifications 1 and 2 to count 15, count 16, specification 1 to count 16, count 17, and specification 1 to count 17, count 18 and the specification 1 to count 18 and counts 19, 20, 21, 22, and 23. Court will therefore accept the pleas of guilty to those charges and specifications and enter finding of guilt as to each one of those charges and the related specifications. As I indicated earlier, the court will schedule a sentencing in this matter once the remaining charges and specifications have been adjudicated and a finding made as to those, either by the jury and or the court. And we'll proceed accordingly. Just so it's on the record, we had discussed yesterday, gentlemen, the situation with regard to the violent sexual predator specification that remains, or to the extent any of those remain, that perhaps defense counsel was going to assert a different position to the court than what they did before and ask that the court determine those rather than the jury at this point. Is that correct?
Yes, sir.
Okay. So therefore, from a procedural standpoint, we won't be conducting an additional evidentiary hearing as to the violent sexual predator specifications. Once the jury returns its verdict, I'll render a decision on any remaining violent sexual predator specification, and I'll make a determination on those. Anything else we need to address then at this point in time before the jury gets back at 10:30? Mr. Tennell?
Can we finish?
Sure.